Baloi.
As the court pleases, perhaps the first issue is the one that was raised by Mr. Mgomezulu and to some extent by...
I know I'm not representing accused number 1 and 2, but it's not about the proceedings, about all the accused.
Yeah, no, quite.
And the interpretation from the submissions made by Mr. Mgomezulu has not been interpreted, my lord.
No, this gentleman.
Submissions?
He's going to interpret all the submissions made. He's got the heads and he's listening. And he has already interpreted the evidence in chief of the state. Am I correct, sir? That has been interpreted. So what he must interpret is the arguments by Mr. Mgomezulu and Mr. Ramosepidi.
Yes, but my lord, it is important that they follow the proceedings as well, that the interpretation be done during the proceedings.
No, that will be awkward. Because when he coughs and says, he must also cough so that it's contemporaneous. Are you saying that? Please. Right, Mr. Ramosepidi. Mr. Baloi.
As the court pleases. The first issue pertains to the argument advanced by Mr. Mgomezulu, and is also contained in the heads by Advocate Mshololo that the state did not prove that the 3 officers are justices of the peace.
Yeah, I remember
Just
that.
want to refer them to this handbook by Ditoy and others, Commentary on the Criminal Procedure Act, at pages 2, 4,
yeah.
and in the middle of the page, the learned authors state the position as follows. A commissioned officer of the South African Police is, in terms of Section 4 of the Justices of the Peace and Commissioners of Oath Act 16 of 1963, read with the first schedule to that act ex officio, a justice of the peace, and therefore entitled to take a confession. We did make this point in passing in the beginning, but they are ex officio justices of the peace, so there's no need for the state to prove anything. My colleague Mr. Mgomezulu was contending that they should have presented the appointment certificates to that effect, but we submit, my lord, that they are ex officio justices of the peace.
Okay.
Then
there's a case, if you want to hear some more about this.
Yes.
By Fagan, 1955. It gave us for that exigency. I'll give you the full quotation. Yeah, so what else do you want to raise?
Yes, then reference was made to the decision of State versus Toki and others.
Yes.
The court requested a full decision.
Yeah, they gave me a half a judgment.
Yes. We have the full judgment here. It's to start with. It's
a case judgment.
A decision by a single judge sitting on circuit in the Eastern Cape division. So,
what's the legal status of a judgment like that?
Yes, in terms of the stare decisis principle, it's not really binding on this court.
Okay.
And secondly,
maybe it's persuasive at the West. And
secondly, the reading through the judgment, we submit that the judge made these comments orbital. In other words, they are not the binding part of his judgment, because he gives his judgment, then after giving his judgment, he then goes on these issues, amongst others, regarding the
advisability or not.
The interpreter. And the facts in the present case are different from the facts in that case, because in that case the commission officers were in the same, unit as the investigating officer, and his remarks pertaining to the interpreter must also contextualize, because he says just before I get to that, the point that I wanted to make, that his remarks were obiter. At paragraph 45, he says, for these reasons, he pronounces his verdict. Then the case presents another example of one where the state case is predicated on confession made by the accused. Then he goes, he says serious issues emerge which call for comment. So, he's just giving a
but the ratio dividendi there, it's basically that...
a comment.
He says the legislature must consider making it a binding legal precept that interpreters should be, as a matter of law, required even to interpret for justices of the peace.
Indeed, my lord.
That's what he says.
Yes,
basically.
but the difference there is that the reliability and accuracy of the statements were called into question. So the correctness of the interpretation had to be proven. That's it. Whereas in this instance, my lord, the accused merely denied that they made the statements. In paragraph 49, it says it is clear from the evidence in the present matter that the investigation team sometimes elected to make use of commission officers who were either part of the investigating team or part of the personnel at the same police station when seeking recordal of a confession or pointing out, as he calls them, in-house commissioned officers, which is not the position here. Then at paragraph 50, the paragraph that my learned friend referred to, it says, all too frequently commission officers who record confessions do not use the services of an interpreter. Then on the next page, he continues that he says the following: the reliability and accuracy of the statements is frequently called into question. It is frequently asserted that the statement was not recorded correctly and was not read back to the suspect, whether in English or language of origin. But as we have already submitted, my lord, that this case is distinguishable in the sense that the accuracy of the interpretation is not an issue.
But actually, the defense here is that these statements were made by the police.
Yes, indeed. Then, regarding the points that were made by Mr. Ramusipili, we have already made this point regarding the approach that the court should follow. We have already made this point that it is two-stage inquiry. The court will have to determine whether Section 217 admissibility requirements have been met, but these requirements must be read subject to the constitutional requirements. Section 35, as we've pointed out, the rights of the accused, but more importantly, Section 35(5) of the Constitution, which requires that evidence to be excluded if it was obtained in a manner that violates any right in the Bill of Rights.
Yes. Fine. Yeah.
And we've already submitted, my lord, that the state has succeeded in showing that no assault had taken place and that the accused rights in terms of Section 35 of the Constitution were explained to them. We've referred to the relevant exhibit. We therefore stand by the submission, my lord, that absent evidence of assault and that Section 35 rights were explained to the accused, then Section 35(5) has not been triggered, because the trigger for Section 35(5) is that it must be shown that a fundamental right as entrenched in the Bill of Rights has been infringed. And in our submission, my lord, the weight of the evidence in our submission is that the statements were not obtained in a manner that violates any right in the Constitution. Mr. Ramsepile just submitted now that the lengthy or the sleep deprivation and the detention of accused number 2 under circumstances that he described amount to torture. We, in our submission, my lord, there's no evidence that there was a deliberate, as we have already indicated, that there was a deliberate act to influence the will of the accused. We submit that there's no evidence that indicates that the police did anything to try and bend the will of the accused.
Who's the judge, by the way, who uses that language? Is it Schutz?
Yeah, I think Schutz.
Schutz,
yeah,
yeah,
Schutz.
yeah. Okay.
Yes, Schutz. It was held that there has to be a connection between the assault as well as the making of the statements.
That's the case of Mchinin, then, eh?
Yes.
Where my brother Mutata was appearing.
Yes,
2000.
indeed.
Oh, 1999.
Yes, indeed. Where I think it's been quoted by Mr. Ramsepile, where I think Judge Scott said that you don't look into a trial within a trial. You don't peer into the trial within a trial as well as the main trial, but you said it's a one-way glass. You know, you can look into what was said in the main trial, but you cannot, when you're busy with the trial within a trial, look at what was said in the trial. But when you're busy with the main trial, you cannot look at what was said in the trial within a trial.
Okay.
And yeah, there's this case that the authors Ditoy and others refer to of Ntanison and others, where the court held that it was Judges Prela and Kumalo held that evidence to be admissible because even though the appellants had been assaulted prior to making the confession, it has not been shown that any causal connection had existed between the assaults and the making of the confession as required for the operation of Section 35(5). But in our submission, my lord, there hasn't been in our submission, my lord, proof of any assaults on the accused persons. And just further on, the authors refer to the test that must be applied, and they say the confessions will be excluded if the accused's freedom of volition is sufficiently impaired. And we submit, my lord, that there's no such evidence.
Sorry, just give me the full citation. It was in Pretoria, this case, ne? Preller and Kumalo were sitting here.
Yes, there was a dissenting judgment, but I see it's Bakani and others. 2017, volume 1.
Wait, Bakani and others.
2017, volume 1, SACR 576.
Okay. And that page on the do it, it's page number 2, what?
It's page 24. 24 to 61.
61.
Yes, 24-61.
Okay.
Then just few aspects that were raised by Mr. Mgomezulu and Mr. Ramsipil as well, that the J50 was obtained for accused number 1 under false pretense. We submit that Brigadier Gininda has sufficiently dealt with that aspect. In fact, the evidence is to the contrary. That case, the Tembisa case, was taken to court and it went through its paces in court. We therefore submit that there was a just cause, my lord, to obtain the warrant against accused number 1.
It was the drug test, the drug case. The one in Tembisa, was it the drugs one?
Yes, the drug case, my lord.
And it was finalized?
No, I'm sorry, it was possession of firearm. Possession of firearm and ammunition.
Is that the one that was that went through the whole hog?
Yes.
And was finalized?
And was finalized, my lord.
Okay.
Then just aspects that were raised by Mr. Ramusipili this morning. The first one is the contention that the report that accused number 1 made to a magistrate regarding an assault during the proceedings of the 10th of July 2020, that the magistrate should have explored this further. We submit, my lord, that the evidence is on record by Sergeant Mohola that she did approach accused number 1 regarding a statement, but that accused number 1 did not finish any statement. This was also confirmed by Brigadier Gininda. Then another aspect that was raised by Mr. Ramusipili relates to the alleged assault during the pointings out on the 5th of June 2020. And in this regard, we just want to refer to the proceedings of the 23rd of October 2023 at page 55, beginning from line 19. Mr. Mgomezulu, he says the following: to forcible arrest, and that is accused 1 was transported from Vilera police station to forcible arrest, and he says the following, to Alberton, Mr. Mgomezulu, to forcible arrest, and he was subjected to torture and assault by the TRT police, who then took him to Alberton. After that, he was, according to his instruction, he was instructed to point out the place where the incident took place. After that, he was transported from Alberton to a certain place. Then on page 62 of the record of the 16th of February 2024, the 6th of February 2024, my lord, when he was testifying, accused number 1 then says, line 3, accused 1, I knew, my lord, that I would come here, and he was now asked as to why did he not confirm what Mr. Mgomezulu said about being assaulted and tortured by the TRT police. He then says, I knew, my lord, that I would come here and testify and explain as to how everything happened. As I'm saying that it was the traffic cops or traffic officers that were there in Vosloorus, and upon arrival in Alberton, then we found the TRT police. So once again, my lord, what the accused is saying is at variance with what his counsel put on record. Then regarding the reporting of the assault at Villeria police station to a police officer during the proceedings of the 6th of February 2024, from line 10, my colleague Advocate Sibanda puts it to accused number 1 as follows. Okay, you also testified in this court that there's a certain man that came, a police officer, according to contacts, that came to you and asked you about the assault at Villeria police station. Then accused 1 responds, yes, I did say so. And Advocate Sibanda, when was that? Accused 1, I do not remember the day as to when it happened, because as far as days are concerned, I'm unable to recall that, or on this day this happened, and on a particular day this is what happened. Then Advocate Sibanda at line 20, so you cannot even recall the said police officer, his surname at least. Then accused number 1, he never mentioned the surname. Mr. Sibanda, was he in uniform? Accused number 1, yes. And Mr. Advocate Sibanda then asked him, is the name not written on the badge of his chest? And accused number 1 says no. Here, my lord, we make the submission that the evidence of accused number 1 is vague. He lacks details of the police officer to whom he allegedly reported the assault. There's no evidence that he made any follow-up regarding that complaint, and there's evidence, my lord, by Lieutenant Colonel Swanepoel that there's a change of shifts every 12 hours, cell inspection every hour, and there's also, my lord, the IPID that's also in the picture that's monitoring any abuse of power by the police, and none of this, my lord, was activated. We therefore submit, my lord, that this version by the accused, it's not true. My lord, these are the only aspect that we wanted to reply on, my lord.
Okay, thanks. Mr. Interpreter, what's your time there?
It is 2 minutes before 1.
Okay, you've got the heads, ne?
Yes, madam.
You must take the heads of Mr. Ramasipiri, all the heads.
Yes, madam.